This conference will now be recorded.
Welcome to DRTSPR channels. This is Dr. Tangella Shiva Prasad Reddy alias Dr. TSPR. Namaste, Adab. Namaste, Adab. Hello and a warm welcome to a special show wherein I am trying to bring you the absolute information in regards to 41A CRPC or 41 CRPC, so and so forth. Because there is lot of issue is going on in Telangana, likewise in other states across India. After Supreme Court issued some guidelines in the case of arrest in relation to the offences which invite punishment under 7 years or 7 years, there is an embargo to arrest. They need not arrest, they issue a notice and subsequently trial by the court can happen. So in this pursuit, because in Telangana there have been a lot of issues going on, right from Telangana State Public Service Commission leak affecting 30 lakh youth, and they add their families, 1 to 1.5 crores, major chunk of the Telangana population. They are literally suffering because of the leakages. Constitutional authorities like governor's office and all, they're keeping quiet and they say there is a big conspiracy going on. On the heels, again there was a 10th class Hindi paper leak. The commissioner of Warangal was also trying to put facts on record when he stated that Mr. Bandi Sanjay, MP, or the president of Bharatiya Janata Party Telangana, has been arrested, and he quotes 51 CRPC because 51A CRPC comes with certain exceptions. If it has to become 41, I mean 40, sorry, I'm subject to correction, 41A CRPC, as per Supreme Court guidelines, as I've already mentioned, arrest cannot be made, should not be made, but exceptions under 41 CRPC, what are those exceptions? Where, how can such exceptions can become a reality? That also we will try to understand, because I am trying to play a video done by Indian Police Foundation, and I am very thankful to Director General of Police then Dr. Ish Kumar ji, thankful to Dr. Ish Kumar ji, DGP, and also to the former judge Muhammad Barkat Ali Khan, who is now the public prosecutor, Vizag Sessions Court. Courtesy to both of them, I am playing this video to clear all those legal doubts in the minds of the citizens. And I have taken their permission, and this will be uploaded on all DRTSPR channels, DRTSPR channel, Citizens DRTSPR channel, and Environment People DRTSPR channels. We will generate link and upload so that citizens or anyone can refer to that and give credit to the Indian Police Foundation who have allowed me to upload this. ఎందుకంటే భయం ఎటు చూసినా 41A CRPC ఏంది, నిన్న మొన్న TSPC నుంచి మళ్ళీ SSC వరకు అరెస్టులు 41A CRPC కింద జరుగుతూ ఉన్నాయి. సుప్రీంకోర్టు ఉచితమైన న్యాయస్థానం కూడా ఇచ్చినటువంటి సలహాలు సూచనలు 7 సంవత్సరాల లోపు అయితే అరెస్ట్ అవసరం లేదన్నారు. కానీ దానికి అక్కడ ఒక ప్రత్యేకమైనటువంటి పరిస్థితుల్లో నిన్న వరంగల్ కమిషనర్ గారు ఏదైతే చెప్పారో ఆ ప్రత్యేకమైనటువంటి పరిస్థితులు ఏ విధంగా వాటికి వర్తిస్తాయి, ఆ విధంగా మనం తీసుకుపోతున్నాం. ఎందుకంటే సామాన్యులు జర్నలిస్టులు ఎవరంటే వాళ్ళని అరెస్ట్ చేస్తూ ఉన్నారు. ఎందుకంటే యూనిఫామ్ వీసే మెన్ ఇన్ యూనిఫామ్, హ్యూమన్ ఇన్ యూనిఫామ్, యూనిఫామ్ క్యాడర్ అంటే దే ఆర్ ఇండిపెండెంట్, దే షుడ్ కమ్ టు ది రెస్క్యూ ఆఫ్ ది పబ్లిక్. సో రాజ్యాంగాన్ని అనుసరించే చట్టబద్ధంగా రాజ్యాంగబద్ధంగానే ఉండ అంటారు. సో దే ఆర్ లా ఎన్ఫోర్సింగ్ ఏజెన్సీస్. దే షుడ్ నాట్ హ్యావ్ ఎనీ ప్రెజుడిసెస్ whether to support this party or that party or any other nepotism or favoritism, without which they should act. దాని గురించి వాళ్ళని we are calling them as uniformed services. Police is one amongst them, and 41A CRPC is creating ripples across India and more so in Telangana very frequently. That is why this show, which I am going to show you, record and upload This is in larger public interest, due courtesies Indian Police Foundation.
Next session, which is about changes in the arrest law, which of course we have already spoken, number of speakers have spoken, but the focus should be on the what are the irregularities committed by the police, what are the known compliances to the amended arrest law, what is the police discretion. So it's a combined session. There are 3 speakers in the session. Although original time allotment is 15 minutes, but we are running half an hour late. So I would request each speaker, if he can cut short by 2 to 3 minutes, that would help us. And if they can conclude in 12 minutes. The first speaker I would invite is Shri Muhammad Barkat Ali Khan Sahab. Now he is a public prosecutor at the District Court, Visakhapatnam. Earlier, he has served as a metropolitan magistrate at the Hyderabad, and I know him from the days when he used to teach law at the Telangana State Police Academy. I must mention that still there are a number of SHOs and sub-inspectors who are regularly in touch with him, and whenever they have a problem, they would take his telephonic advice how to get out of that situation. So, Shri Barkat Ali ji. Sir, please start. You may please start.
Thank you. Thank you so much, sir. As good morning, one and all. As sir has narrated, I had 7 long years as a law faculty at the Telangana State Police Academy, and I have thousands of sub-inspectors, inspectors, and various officers of all levels calling me every day. I receive calls and clarify their doubts whenever they come up. The topic allotted to me is about 41A, and Arnesh Kumar, 41B, C, 50A, 55A, 60A. I would like to condense the topic due to paucity of time as expressed by our sir. The power of arrest is governed by Criminal Procedure Code. Arrest is a part of investigation. As the words of the Supreme Court go, it is a part of the investigation where it starts with registration of FIR and all steps taken by the investigating officer, collection of evidence, proceeding to the spot, arrest of the accused, and collection of physical evidence and other evidence, and finally laying a charge sheet. It all is covered under investigation by the police. So it is not as if the arrest is a prerogative of a police officer and he has unfettered powers. It has always been regulated by the CRPC as well as the judicial pronouncements made at various points of various occasions. The Supreme Court and other high courts have come down. So the main lacuna I find in the police officers is interpretations of Section 41A. It has been surrounded by controversies of late, where police officers action has been taken against the police officers. Recently, as told by my predecessor speaker, in Telangana, 4 weeks jail has been imposed on a joint CP, AR Srinivas, Banjara Hills, and ACP, Circle Inspector and Sub Inspector. So 4 weeks imprisonment for contempt of court for not following Arnesh Kumar guidelines. Similarly, I have come across my own student who was convicted for 15 days imprisonment. Later on, he felt sorry for it and started ringing me up as to how to get out of this situation. I asked him to submit an unconditional apology to the court and come out of this situation. But unfortunate for him that 15 days imprisonment was confirmed even by the Supreme Court. It is a time to learn that there is a thin line of demarcation between a power to arrest and danger looming large. It's time to know the procedures. Interpretation is very much important. Section 41A, literal interpretation doesn't give you a complete picture. A complete picture emerges only after you go into the decisions rendered by the Supreme Court. So who can be arrested? To whom a 41A notice, who can be arrested is listed out. Various circumstances or various situations under which a person can be arrested is listed out under section 41 of CRPC. Now the crux of the issue is 41A and it is to be issued. So you have two situations. One is section 41 where the police officer intends to arrest the accused or any person. 41A when you have made up your mind not to arrest. So you have a discretion. Recently I have come across many situations where the magistrate is refusing to remand the accused. Remands are being refused and returned back. Then the police call me immediately, sir, how can we get over the situation? Remand has been refused by the, that you have not followed Arnesh Kumar and all. So the moment the remand is refused, you are bound to enlarge the accused immediately from your custody. Otherwise, it would amount to a wrongful confinement. I have advised them. And 41A can be issued not only to a accuser. It can be issued to anyone who, against whom there is a reasonable suspicion that he has committed an offense or information is there. Also can be issued a notice under 41A. It is not a rule that only he should be accused as per 41A in a criminal case to issue a 41A notice. Now, once a notice is issued under 41A and the concerned person complies with the notice and presents himself before the police officer and complies with the conditions of the notice also, he shall not be arrested. Make it a point that he shall. Only for reasons to be recorded, he can be arrested is mentioned in 41A. But once a notice under 41A is issued, you are not supposed to arrest the accused unilaterally now. If he does not comply with the conditions of notice or he doesn't follow the conditions, then you should seek the permission of the magistrate. Recent judgment of the Justice Lalita Kumari has given the judgment in Telangana that once you issue a 41A notice, you shall not arrest unless you seek the permission of the concerned magistrate. So, if you want, it is not as if Arnesh Kumar gives a blanket prohibition for arrest, imposes a blanket prohibition for arrest. It gives out situations wherein you can arrest even though the offense is punishable up to 7 years or less than 7 years. You are entitled to it. There is a checklist provided under section 41 where the offense is punishable for less than 7 years. Yeah, there are certain situations. A checklist is to be enclosed when you remand the accused to the magistrate. You justify your arrest. Why you want to arrest, even though the offense is punishable for 7 years or less than 7 years? Why do you want to arrest? You should mention it elaborately in the remand report. Explain it so that the magistrate remanding the accused is satisfied that though the offense is punishable for 7 years or less than 7 years, the concerned investigating officer has exercised his discretion under section 41 and he chose to arrest the accused rather than issuing a notice under 41A. Now, no lip service. Generally they say, is he dangerous? Yes. Will he repeat the offense? Yes. Produce some material in the remand report. If he has previous crime numbers so-and-so, crime number so-and-so, crime number, he has a tendency and propensity to repeat the offense. So mention the crime numbers. That will justify your arrest. Rather than a lip service, you place material before the court to justify your arrest. You will not land in a trouble of violating the Arnesh Kumar rules. Now again, you say he will not be available for trial. There must be past instances where he has jumped bail on many occasions. So when he has jumped bail on, it shows a tendency that he has scant respect for the process of law he will not be available for trial even in the present case. So mention the occasions, earlier occasions, his antecedents where he has jumped bail and has been eluding the law enforcing agency. So this would place a material before the court to come to a conclusion whether to accept the arrest or the arrest is justified or not. A checklist is given in terms of 41 to 41B2, where the checklist has to be filled up by the police officer effecting the arrest, even though the offense is punishable for 7 years or less than 7 years. Now, it is not only incumbent upon the police officer, but also the magistrate to see that mechanical arrest is not made, and further, he should scrutinize the arrest, and mechanically the magistrate also cannot remand the accused if the checklist is not satisfied. So, I have seen remands being refused.
Barkat Ali Saab.
Yes, sir.
2 minutes or bus. Please close in 2 minutes more.
Yes, yes, sir. So, winding up, notice 2 weeks prior notice. Arnesh Kumar contemplates 2 weeks prior notice to the court that he is not arresting, and also to the accused. Accused is would not be under a mental trauma that he is left in a dilemma whether he will be arrested or not. A notice will give him a sufficient confidence that he is not going to be arrested. So 41A must be followed in letter and spirit. Arrest is casts a big stigma on the accused person who is arrested, and his social reputation goes down in the society. So the procedures may be followed. The sub-inspector sometimes ask, before winding up, sir, my students ask, how can I get over this Arnesh Kumar? Is the question put to me, my students. Innocently, they put questions to me. How can the complaint be manipulated so that some higher provisions of law can be attracted, penal provisions, so that we can send him inside or something? There should be a change in the attitude of the police. There should be sensitization of the lower rung police officers, orientation classes to be held, and there should be a change of attitude, sir. They ask what masala can be put in to get him out of the Arnesh Kumar ambit is the question put by the police officer. This is a sorry state of affairs. There should be they are not inclined to enforce Arnesh Kumar, rather than they are searching for loopholes to come out of the net of Arnesh Kumar. This is the sum and substance, sir. The lower rung, especially the sub-inspectors who lack sufficient knowledge, need to be sensitized about this aspect, sir. So, in all, Arnesh Kumar, they have faced consequences. They have faced jail term. The warning bells are already on. It's time that a orientation class is held for all the lower rung police officers, and a change of attitude is incorporated in their minds towards respecting law, and see to it that the rule of law prevails in the country. Thank you so much, sir. Thank you so much.
Thank you, Shri Barkat Ali ji. Mr. Barkat Ali basically gave lot of examples as to while arresting a person, how to justify the arrest on the record before the court. So what all can be added? Basically, he's trying to help investigating officers, and but the attitude, how to get over the Arnesh Kumar judgment and what can be done, it's the alarm bell, and he rightly says that the police officers need to be sensitized. I will just mention here 41B, which was introduced.
Yes.
It talks of that when you arrest a person, a memorandum of arrest has to be signed by one family member.
Yes.
That's an amendment that while similarly, the 41C says that at the control room, all the arrests made and the police officer who made the arrest, their names must be displayed. So that is the amendment at the 41C. I'm not sure how much it is being followed.
Not followed.
Not followed. And then the 41D says that during the interrogation, an accused has a right to contact his lawyer. He may not be present throughout the interrogation, but he can definitely come and he can meet the liar.
Yes.
And similarly, as per 50A, there is an obligation for a police officer to inform one person at least that so and so has been arrested. So that again information has to be sent. These were the changes recently made. We'll move to the next session. I hope Mr. Umapati is there.
Okay. So this is for the sake of citizens to be sensitized along with the police personnel. And once again, I leave it to the discretion of all concerned uniform services personnel that rule of law should prevail, come whatever may, and they should infuse and such type of confidence in the people, because citizens are the constitutional authority in India. It's not a banana republic, and I'm thankful to Indian Police Foundation, Dr. Ish Kumar ji, Director General, as well as Dr. Barkat Ali ji, former judge and present public prosecutor, Sessions Court, Vishakhapatnam or Vizag. This is in larger public interest, and this will be there available on all the three channels: DRTSPR channels, Citizens DRTSPR channel, and Environment People DRTSPR channels, for every citizen to understand what 41, 41A, B, C, D all are all about. Once you understand, your fear is gone. And again, we always say, never indulge in any criminal activities at the cost of suffering of others. Because you are a Maharaja, you are a constitutional authority. There should be equijustice so that everyone can live in harmony and with absolute peace. And we are all guided by this wonderful constitution of India, which anyhow we are going to celebrate in a few days from now. But DRTSPR channels celebrates as and when the occasion arises to make the citizens informative. We provide the information for a wonderful guest like Indian Police Foundation also has allowed us to upload this in larger public interest, so that that fear is gone, so that every citizen has a right to take a decision. Similarly, the message is also to all uniform services here, the police personals and others. Thank you very much. Do support DRTSPR channels, Citizen DRTSPR channel, and Environment People DRTSPR channels in larger public interest. Subscribe, share, and support, as we are going to complete 3 years, the stroke of 26th May 2023. That is the third anniversary. And thankful to all those wonderful guests and all the patronage received by all the corners. Thank you very much. Take care. Sarve Jana Sukhino Bhavantu.